Hello, Rob Ryder again. We're going to talk about why it's so important to have these seals and try to create a public record. And again, if you're looking for things I've done in the past, there's the WordPress site at the top. Uh, right now, we're going to concentrate on Book 3, Chapter 22 of the Special Species of Trials from Blackstone's Commentaries in English Law. And there is a link to an ebook. But if you go to someplace like openlibrary.org or similar and put in the word Blackstone, you'll find all sorts of different books you can look at, edited versions. This happens to be an online one, um, and there it is. So I'm not going to read everything in this chapter, just picking out the things that mean something to me. So, the uncertainty of legal proceedings is a notion so generally adopted and has so long been the standing theme of wit and good humor that who should attempt to refute it would be looked upon as a man who is either incapable of a discernment of himself or else meant to impose upon others. So, either you don't understand what's going on or you're one of those who are going to take advantage of those who don't understand what's going on. You're going to charge your brother. Yet it may not be amiss before we enter upon the several modes whereby certainty is meant to be obtained in our courts of justice to inquire a little whether this uncertainty, so frequently complained of, consists and to what causes it owes its origins. So eventually, the main thing in this is we're going to figure out whereby certainty is meant to be obtained. Might have something to do with these records that I'm trying to get everybody to understand. Um, People are apt to be angry at the want of simplicity of our laws. They mistake variety for confusion and complicated cases for contradictory. They bring us examples of arbitrary governments, and you'll find out arbitrary means they have very few laws, such as Denmark, Russia, Prussia. Wild and uncultivated nations, the savages of Africa and America, so on and so on, um, require the same fewness of laws, the same conscience of practice in a nation of free men, a polite and commercial people, and a populous extent of territory. And arbitrary, subject to individual will or judgment without restriction. That's where I want to live. In arbitrary, despotic government, where the lands are at the disposal of the prince, they're talking about you, and the land is your body, the rules of succession or mode of enjoyment must depend upon his will and pleasure, not your will that you write when you're dead, by your will as a man. Hence, there can be but few legal determinations relating to the property, the descent or the conveyance of real estate, and the same holds in stronger degree with regards to goods and chattel and the contracts relating thereto. So, in a arbitrary, where subject to individual will or judgment without restriction, uh, there's no question who gets what. You don't have to tell anybody, it's by your will. Under a tyrannical sway, trade must be continually in jeopardy, and of consequence can never be extensive. It is therefore puts an end to the necessity of infinite number of rules, which the English merchant daily reoccurs to and for adjusting commercial differences. So they're telling you this is the difference between law and equity or amity. One's meant to have a bunch of things wrong with it. Let's see if there's anything here we need to read. Uh, Marriages are there usually contracted with slaves, or at least women are treated as such. No laws can therefore expected to regulate the rights of dower, jointures, and marriage settlements. Few also are persons who can claim privilege of any laws, the bulk of those nations, uh, the commonalty, boors, the peasants, being merely villeins and bondmen. So in their system, that's what you are. You're a person, and these are the things you get to be as a person. You get to be a villein, or a bondman. And a bondman, that has to do with indenture, and there's a thing called indenture deeds, which we'll be talking about in another video. Those are therefore left to the private coercion of their lords. If you're a person, if somebody else is your lord, whatever they want to do to you, they can. We may see in these arbitrary states how large a field of legal contest is already rooted up and destroyed. So these arbitrary ones, they've gone through this before and they tore that shit out. They've uprooted and destroyed, replaced some system of civil law in its legal contest with something else. Again, were we poor, naked people, as savages in America, strangers to science, commerce, arts, as well as convenience as of a luxury, the convenience as of a luxury, so if we can convince you to do our work for you, then you will, we might perhaps be content, as some of them are said to be, to refer all disputes to the next man we meet on the road, and so put a short end to the controversy. Go to your brother first and settle the matter. For in a state of nature, there is no room for municipal laws, and the nearer a nation approaches the state, the fewer there will have occasion for. So the closer you can get back to the state of nature, instead of the United States of America, the less laws there are. When the people of Rome were a little better than sturdy shepherds and herdsmen, all their laws were contained in 10 or 12 books. But as luxury, politeness, and dominion increased, the civil law increased in the same proportion and swelled to that amazing bulk which it now occupies. He's talking back in the 17th century. How big is it now? The causes, therefore, of the municipality of the English law are the extent of the country which they govern, the commerce and refinement of its inhabitants, but above all, the liberty and property of the subject. Yeah, how much liberty and property are they going to give their subject? If you're a subject to English law, they're going to decide how much you get by statute. It's the same in America. It's the same anywhere civil law is in place. These will naturally produce an infinite fund of disputes, which must be terminated in a judicial way. Well, imagine that. They're going to poke at you with a stick and make you go to court and then take your stuff. So, you can either keep doing that with them or see if there's a better way. Because they said earlier in this that there's a way to get certainty in a case. But though in many countries everything is left in the breast of the judge to determine, yet with us he is only to declare and pronounce, not to make or new model the law. The judge is not there to make new law, he's there to declare and pronounce. So if you're the tribunal and a judge is a judicial magistrate, and in law the judicial magistrate's merely there to administer the orders of the tribunal, you make the law and have him declare it and pronounce judgment. So let it be written, so let it be done. But wherever this happens to be the case in any material points, the legislature is ready and from time to time may both, and frequently does, intervene to remove the doubt, and upon due deliberation determines by declaratory statute how the law should be handled in the future. Well, the U.S. Constitution says full faith and credit given to all public records, acts, judicial proceedings, forming the highest level of evidence there is, full proof of public record. I think it says in the Magna Carta also, the full faith and credit says that. Whatever instances, therefore, of contradiction or uncertainty may have been gleaned from our records or reports must be imputed to the defects of human laws in general and are not owing to any particular ill construction of the English system. Indeed, the reverse is most strictly true. And the reason for that is the English system is based on common law, and common law is merely the unwritten law of reason. Whatever is reasonable to a man is the law. So when you go on it as the man and are reasonable, it's the law. I don't know how much more strict you can make it on them. The English law is less embarrassed with inconsistent resolutions, doubtful questions, than any other system of the same extent and same duration. Just a second. I'll take this phone call. Okay, we're back. Um, Sorry about that. I'm going to see how this works. I've never had to stop one in the middle. I hope I'm where I left off. Anyways, in this particular thing, the main thing I want you to see is the red. The same may be said of canon law, though the text, therefore, is not half the antiquity of canon law of England, or excuse me, common law of England. So, first in line, first in time means common law of England has more power than canon law of the Vatican. And all civil law comes from canon law, which makes it inferior to common law. It didn't say English common law. It says the common law of England. And Blackstone's defines common law as the unwritten law of reason, period. It's the unwritten law of reason. What's reasonable between two men? That's the law. And only a man can bring a claim against a man. A person cannot. They don't have the status. Man was created in God's image, not person. Where therefore a body law is so high antiquity as English is in general so clear and perceptuous, it argues deep wisdom and foresight in such and laid the foundations and great care and circumspection in such as have been built the superstructure. So basically, he's talking about the maxims of law, right? The maxims of law were written down, but they were known well before they were written down, and they covered everything about how men treated each other, not just in commerce, but just as neighbors, as each other. And those are the maxims of law, and they cover many, many projects. They are the law. You can always go back to the maxims. Or you can just go to common law and invoke common law, the law of reason. And that's what we're doing. But as not, it will be asked, the multitude of lawsuits which we daily see and experience. Now, this is 1700s, man. He's talking about it back then. An argument against the clearness and certainty of the law itself. You would think so. What's the law? We have all these lawsuits all the time. By no means, for among the variety of disputes and controversies which are daily to be met with in the course of legal proceedings, it is obvious to observe how very few arise from obscurity in the rules or maxims of law. And a rule we get to use is that the Public Record Act judicial proceeding has full faith and credit. So they never break the law. It's just that the law is never invoked. An action shall seldom be heard to determine the question of inheritance unless the fact of descent be controverted. But this dubious points, which are usually agitated in our courts, arise chiefly from the difficulty there is of asserting the intentions of the individuals in their solemn disposition of property, in their contracts, conveyances, testaments. It is an object indeed of the utmost importance in a free and commercial country to lay as few restraints as possible upon the transfer of possessions from hand to hand, or their various designations marked out by the prudence, convenience, and necessities, or even by the caprice of their owners. Yet to investigate the intention of the owner is frequently a matter of difficulty among heaps of entangled conveyances or wills of the various obscurity. The law, rarely hesitates in declaring its own meaning, but the judges are frequently puzzled to find out the meaning of others. Thus the powers, the interests, the privileges, the properties of the tenant for life and the tenant entail are clearly distinguished and precisely settled by law. But what words in a will shall constitute this or that estate has occasionally been disputed for more than 2 centuries past. He's in the 17th century. He's going back to the 15th. More. He's going back to when the shit started around the 13th century. and will continue to be disputed as long as the carelessness, the ignorance, or singularity of testers shall continue to clothe their intentions in dark or newfangled expressions. So if you're writing wills, you're getting yourself in trouble. You're causing a problem based on this. So we've got to find out how we're going to rectify this. But notwithstanding so vast an ascension of legal controversies arising from so fertile a fund of the ignorance and willfulness of individuals, these will bear no comparison in point or number to those which are founded upon the dishonesty and disingenuity of the parties. Well, guess what? You think somebody's taking advantage of you? Well, he's telling you they are. Not that we don't know it. It's here in the law book. He's telling you what they're doing to you. So maybe he has an answer. Let's see what the man has to say. By either they're suggesting complaints that are false in fact, and thereupon bring groundless action, or by their denying such facts are true, and setting up unwarrantable defenses. Oh, so they're going to deny facts are true. Ex facto retior jus. The law arises from fact. If therefore the fact be perverted or misrepresented, the law which arises from thence will be unavoidably be unjust or impartial. In other words, if the right facts aren't being judged, the verdict could be incorrect for the situation. So, and in order to prevent this, it is necessary to set right the fact and establish the truth contended for by appealing to some mode of probation or trial which the law of the country has ordained for criterion of truth and falsehood. So truth comes from fact. In order to prevent this, it is necessary to set right the fact. When you set right the fact, the laws of the country has ordained the criterion of truth and falsehood. These modes of probation or trial form in every civilized country the great object of judicial decisions. And experience will abundantly show that above 100 of our lawsuits arise from disputed facts, for one where the law is doubted of. So because the facts aren't known, they're disputed. If the facts were known, there would be no dispute. Now this isn't in this part of Blackstone's, but it said the word probation, and we're going to change tunes just for a second so we can see what probating means. This is about deeds again, how a deed is proven. It is lawful in many of the states and customary in some of them, as will be further seen below, to prove deeds instead of acknowledging them. That is, one or more subscribing witnesses goes before an officer authorized to administer oaths and makes oath that the grantor executed and acknowledged the instrument in the presence of the affiant and the other witnesses. So, 3 witnesses went, 1 came back and said all of them went. Well, where's the other 2? Or there were 2 witnesses and 1 came back and said they both went. Only 1 took an oath to be in there. To be a witness, you have to have an oath administered. You have to be deposed. And so 1 of them did, said the other ones went, and the officer makes a certificate of this oath on the deed, much as a certificate of acknowledgement is made. And the deed is then, and this certificate are both recorded. In some states, this is termed probating the deed. This is what's happened to not only your real estate, in my opinion, but also your body. In real estate, the deed is the land patent way back, and you can have a certificate that says you're the owner per the land patent. They're both recorded. With your body, your land is recorded also with an initial registration at your birth. And sometime later, some certificates of birth are produced. And these certificates of live birth, according to the Torrens system, says that there's 2. There's the outstanding copy and the owner's copy. And it sounds like as the owner, you're supposed to go accept the certificate and take it back so that you showed that you appeared. Very similar to what we're trying to do with the warranty deed. I don't have this quite clear in my head yet, but that's what I'm working to as far as the body and claiming it as your land and being lawful owner of the landed estate known as your all capital letter name. So from now on, when I write something, I'm already telling them it is, and I'm making a public record that can't be rebutted. All right, so now we're back to Blackstone's. He just talked about, basically he's talking about most of the shit that happens in court has to do with disputing the facts, not disputing the law. And experience will abundantly show that above 100 to 1 lawsuits arise from disputed facts. Well, we got to get rid of these disputed facts then. So trial then is examination of the matter of fact and issue, of which there are many different species according to the difference of the subject or thing to be tried, of all which we will take curious view in this and subsequent chapter. For the law of England so industriously endeavors to investigate truth at any rat, that it will not confine itself to one or to a few manners of trial. The truth can be established many different ways in many forms of trial, but varies in examination of facts according to the nature of the facts themselves. This being the one invariable principle pursued, that as well the best method of trial as the best evidence upon the trial which the nature of the case affords, and no other, shall be admitted in the English courts of justice. Best evidence, best trial. These species of trials in civil cases are 7. We have by the record, by inspection, by or examination or certificate, by witness, by wager or battle. You can still duel if you want to. By wager of law, and by the jury. There's the 7 ways they have trials in civil cases, which is under canon law. Statute law, amity law, maritime law. Take your pick. But let's look at the first one. First, then, of the trial by record. This is only used in one particular instance, and that is where a matter of record is pleaded in an action as a fine, a judgment, or the like, and the opposite party pleads basically that there's no record. Upon this, issue is tendered and joined in the following form. And this, he prays, may be inquired of by the record, and the other does the like. And whereupon parties pleading the record has a day given to him to bring it in, and proclamation is made in court for him to bring forth his record, or he shall be condemned. And on his failure, the antagonist shall have judgment to recover. So right now, when you go in to these courts under trial by record, which is happening on the side of the road with a copper, anytime somebody hands you a paper, the trial by record is started. And he who has the record wins. Because if you don't have the record, you lose. The trial, therefore, of this issue is merely by record. For, as Sir Edwin Coke observes, who wrote an even older version of common law, which also is a book of authority, a record of enrollment is a monument of so high a nature, and imports in itself such absolute verity, that if it be pleaded that there is no such record, it shall not receive any trial by witness, jury, or otherwise, but only by itself. Thus, titles of nobility, as whether earl or no earl, baron or no baron, shall be tried by king's writ or patent only. Or so, trials of nobility. Are you a king or not? Which is all by the matter of the record. Also, in case of an alien, whether alien, friend, or enemy, shall be tried by the league or treaty between his sovereign and ours. And what they're talking about here, the aliens they're talking about would be the Muslims, right? If you're a Christian, your sovereign is the Creator, right? Through Jesus. Well, if you're Muslim, that isn't necessarily the case. So he's an alien, but it still depends on how you treat each other. And also whether a matter be held in ancient demesne, D-E-M-E-S-N-E, or not, shall be tried by record of doomsday in the king's exchequer. That's the book. The Doomsday Book is the one in the Register of Deeds office. Ancient, something old, which by age alone has acquired some force. It's acquired all the force. And that other word, the name given to the portion of the lands of a manor, which the Lord retained in his own hands for his own use of himself and family. These lands were called Terra Domicellis, or Demesne lands, because they were occupied by the Lord. So that's your land. And you have it through ancient. So the manor, which to me is the estate that's being passed down through your history, is based on this ancient demesne, and can only be tried by the record of the Doomsday Book. Well, that Doomsday Book is the one we need in the King's Exchequer, which is the treasury. And we could go into Exchequer for quite a bit of time. Basically that's the treasurer. And guess what? He's a judicial officer, has a special court. Actually says that he has jurisdiction in natural law. I've never seen a court that said that before, but put in Exchequer in Wikipedia and take a look. So this is why we're trying to produce a public record, because it is the highest evidence, and the trial record is only used in one particular instance, and that is whether a matter of record is pleaded in an action. Well, so if you're going down to do this record with your real estate, you've just created a public record. A record or enrollment is a monument of so high of nature and imports in itself such absolute verity that if it be pleaded that there is no such record, it shall not receive any trial by witness, jury, otherwise, but only by itself. If you say there's a record and they don't, and you show it to them, it's over. That's their law. They put their seal on your paperwork saying that you have a public record. And let's go use it. So I have another video out shortly with something else you might use it on, depending on your situation. Have a great day.